Friends, Justice Clarence Thomas said something in the majority opinion today in the gun rights case that should be great news for all constitutional conservatives beyond the issue of guns, and it's tucked in a footnote. And I doubt you're going to hear anybody else talk about this footnote. So listen to it, because what Clarence Thomas began to do is to restrict the nature of the judicial power back to what it's constitutionally supposed to be, and began to undermine the doctrine of stare decisis that is applied to constitutional issues, and kept the pro-life community from attacking Roe versus Wade and Planned Parenthood versus Casey for decades. It is critical you understand this footnote. So listen in. I'll tell you what it says, and then I'll tell you what it means, okay? He cites in footnote 6, the dissent claims that a text and history test will prove unworkable. And what is he talking about there? The majority opinion said we have to understand the words in the Constitution according to the text and the history of the text. What has the common law said about these words and these phrases all along? Now, if we'd been applying that test and insisting on that test for the last 4 decades, the court would have had to have held that the unborn were persons. They would have had to have held that marriage is a man and a woman. We wouldn't have lost all the things that we've lost because we didn't insist on that understanding being applied to the text. But let me keep going on. So the dissent is saying, oh, let's not use this text in history because it'll be unworkable, because judges are relatively ill-equipped to resolve difficult historical questions or engage in searching historical surveys. In other words, the dissent is saying if we start looking at the history and the common law and the history of the common law, well, we can't know everything there is in the world to know about all the history of the world, and this is just unworkable. So here's what he says. We are unpersuaded, period. Great statement. Then he says this, the job of judges is not to resolve historical questions in the abstract. We're not history professors trying to teach and talk about history in the abstract. He says our role is, quote, to resolve legal questions presented in particular cases or controversies. Now that's the critical language, because the Constitution says the Supreme Court has no power except to hear cases and controversies. In other words, judges resolve a dispute between the parties in the courtroom, and they don't make law. We've been living under the false impression for decades, going back to 1958 actually, that the Supreme Court, when it makes a decision, it becomes the law of the land. It does no such thing. They can't make law, and that's what he's saying. We're just resolving a legal dispute between parties. That's all the Constitution lets us do. And then he goes on, and he says, that legal inquiry is a refined subset of a broader historical inquiry. Okay, so we're not asked to decide the whole history of the world in every case. We're asked to decide a particular aspect of history related to a particular word or phrase. And he says, and that method relies on various evidentiary principles and default rules to resolve uncertainties. In other words, we have tools we use to help resolve the uncertainties about what the history is pertaining to a particular case or controversy involving a particular word or phrase in the Constitution. And then he says this is great. This is what undermines stare decisis and this concept of we have to just stick with what we've said in the past, even if perhaps it was wrong. He says, for example, quote, he's quoting another case from the Supreme Court. In our adversarial system of adjudication, we follow the principle of party presentation. Courts are thus entitled, here's the key language, to decide a case based on the historical record compiled by the parties. In other words, we're just deciding the case in front of us based on the record that we have in front of us. And that means when a pro-life community comes in and gives us only this bit of a historical record, we're entitled to rely on that and make a decision. And that's all we've decided is what should happen in that case. And in the next case, a different party, a different state could say, wow, what was Texas thinking, or Ohio thinking, or California thinking by not putting in a bigger, broader, better historical record? And so when they get sued over the same issue, they bring in a different, bigger, better, more refined historical record and say, hey, look at this record. And the Supreme Court is entitled to say, oh, well, you've brought us a different record. And so based on that record, this is how we're now going to decide this particular case or controversy. And we're not undermining, quote, the law, because we don't make law. We just issued a judgment based on the record that was before us, and you've given us a better record, and now we're going to make a judgment for these parties based on that record. My friends, if we will do that, if the states will begin to do that when they pass their pro-life laws, the pro-aborts will never find in the history of the common law that the unborn were never treated as persons. In other words, they can never make a historical record that shows that states cannot treat the unborn as persons. The Supreme Court just made the unborn persons in the United States Constitution under the 5th and 14th Amendments if we will develop the proper historical common law record, and that's already been made by Dr. Robert George and John Finnis and by Adam McLeod and Jeff Schaefer in the amicus briefs that were filed in the Dobbs case. And we were grateful and thankful for the opportunity we had to help participate with Adam and Jeff Schaefer in the brief they filed. So this is great news.